SJC-13548, Commonwealth versus Thomas Mercado.
I would have ordered Diet Coke. Hey, you getting Diet Coke?
I need an IV down here. I'm dying.
Okay, help me with your last name.
Amy Cottignone.
Attorney Cottignone, please.
I think it's afternoon at this point. Good afternoon, Your Honors. Amy Cottignone on behalf of Thomas Mercado. Through the progress of science, we now know that the identification evidence that was critical to Mr. Mercado's conviction is, and I quote, highly unreliable, and that the identification of Mr. Mercado as the shooter is at great risk of being in error, end quote. This new evidence calls into question the justice of Mr. Mercado's conviction, provides him a ground of defense that was unavailable and unpursued at the time of his trial, and is counterintuitive to jurors. The science tells us that they would place, and they did place, undue weight on this unreliable and potentially false identification evidence. In terms of whether or not Mr. Mercado's conviction should be reversed, there's two prongs that this court needs to consider on newly discovered evidence. And last week, the court decided the Gaines case, which I would suggest answers some of those questions. The eyewitness identification science itself is properly considered newly discovered evidence, and the motion judge's finding here is adequately supported in the record. The court found that there was a 15-year acceleration that had occurred after Mr. Mercado's trial and the development of the science. The court found also that this court's decision in Gomes sort of changed the law in terms of whether or not the science was available to defendants in determining that in 2009 the science was not available to Mr. Mercado. At the time that he was tried, defense lawyers were not seeking funds, getting funds, consulting these experts, and now the recognition has changed because we now know that jurors do not understand the science and are unable to apply it without some guidance. So the question, I think, for this court is whether the court correctly reviewed the trial record here. He was not the trial judge, he was a motion judge, and I would ask that after a de novo review and looking at the trial record here, that this court find that where the eyewitness identification science is the only evidence that places Mr. Mercado at the scene of the crime at the time of the crime, and where we now know that that evidence is unreliable, that would have probably been a real factor in the jury's deliberations.
Well, I'd like to talk about that because it's a little bit weird. His own testimony places him at the scene of the crime. I'm not going to say at the time, but like around the time, on the same evening. And it's not a case of stranger identification, except potentially for the victim's brother. And the underlying premise of the expert opinion here is at odds with the defense theory presented at trial. And I don't think that helps the defendant in establishing prejudice. The defense at trial was not mistaken identity, was deliberate misidentification. In other words, these witnesses fabricated.
Yes,
Not that they did not recognize me, but they fabricated that I was the perpetrator.
Sure.
So I don't really see how the eyewitness identification testimony bears on that defense. It may bear on a strategy before the defendant decided to take the stand, but once he took the stand, and this is the defense, I'm having a hard time seeing how this all works out.
So there's two things that I'd like to address there, and that's the familiarity piece, which Dr. Franklin says that the familiarity that was gained from that prior visit to the apartment building earlier is actually evidence that predicts the later identification of Mr. Mercado as the shooter. But just addressing that second part so that I don't forget to, with regard to the defense, I think the point here is that this opens up an available defense that wasn't available to defense counsel at the time of trial. And the defense that was pursued was one of fabrication, right? That Martinez and Cripps were lying to protect the true killer, who was a drug dealer named Pallone. And I can see why that lacked credibility before the jury, because first of all, Martinez had only known Pallone for the 1 week that she was using crack in that apartment. And so her incentive to cover up for some man that she knew for 1 week really doesn't make a ton of sense. The defense also doesn't address why the victim's brother would get up from the witness stand and say, that man killed my brother. It literally does not account for that whatsoever. There's no reason why he would be lying to protect a drug dealer he also doesn't know. And so this gives him a new ground of defense that wasn't really understood by trial counsel.
I'm confused on that, because forget the Jenga tower legal standard,
Yes.
as glib as it is. The legal standard is whether or not the newly available evidence would be a real factor
Right.
in the deliberations as it was done at trial, correct? Not whether or not there would have been a change of strategy had this thing been available.
I somewhat disagree with the court on that, because I think that in some of this court's cases, that the court talks about how it opens up available defenses. So, for instance, in Epps, the defendant didn't have an expert who talked about shaken baby syndrome,
Sure.
And it opened up a new sort of avenue for acquittal. And here, really honest but mistaken identification is a much better defense, because one of the things about identification that Dr. Franklin explains is that when an eyewitness even holds a false memory, but when the memory is encoded in their face, in their memory, such that they will sort of recite it to a jury, they will genuinely believe it when they say it.
When we look at all the cases that we've said it has been a real factor, all the misidentification cases, they're all along the lines of gains. But have we ever applied it when we've had we've had non-strangers essentially, or in this situation? Well, you know, and I understand your theory about it's mistaken because there's a suggestion that someone that was there later on. But
Right.
I get that. But can you tell us, in all the cases we've had, they seem to me to be similar to gains, these quick hitters, you know, misidentifications, as opposed to strangers and non-strangers.
Well, so I think that the difference between Gaines and other cases is that in Gaines, there's an actual alternate avenue to conviction. So if the jury in Gaines believes his confession, which is a corroborated confession, coupled with, you know, the consciousness of guilt, he's arrested in Ohio or something like that, you know, they could convict him in another way. So
Iowa,
there you go.
Don't worry, for those of us from Ohio, we get confused with Iowa all the time.
So, and in other cases, right, there's other paths to conviction. So, you know, in that sense, this is the only evidence that is sufficient to sustain the conviction here, that places him at the scene at the time of the crime. But in other cases, there is other evidence that's suggestive of guilt on which the defendant can convict, because recall, this is not...
He admits that he was present at the scene.
Right.
He admits that he was present at the scene with these people in the women's apartment. He admits that he knew one of the women from before and they had a relation, they were friendly. And we do have consciousness of guilt evidence. So it's not only the eyewitness identification of him is not the only evidence.
And I understand that, but looking at, so for instance, Marrero, this court reversed Marrero's conviction based on DNA evidence earlier this year. There were people that placed Marrero near or at the scene of the crime. He made a statement to somebody as he's fleeing from the crime scene, inculpating himself in the crime, and he, contemporaneous, flees the country. So in that case, it was a real factor in the jury's deliberations, and there's more evidence. In Cowles, there was also consciousness of guilt. He throws away his bloody shoes. He makes statements to the police that are deemed inculpatory. You know, in each of these cases, there is additional evidence. And so the question, I think, for this court is whether it would be a real factor in the jury's deliberations if the jury understands that the identification evidence is unreliable. And to the court's point that there are multiple witnesses, because I think that was a real piece for the motion judge. The exoneration cases, this is a pattern that we see, right? In a third of exoneration cases, there are multiple witnesses. And if you include non-DNA exoneration cases, I think that the statistics are about 40% of those cases, there are multiple people. And the science tells us exactly why that is and why that happens. It's because people are primed to sort of accept and incorporate in their memory details and information that's suggested to them. So shortly after this crime, Martinez did not identify Mr. Mercado as the shooter. Cripps said he was a man in the hallway, which the familiarity primes her to do. She's, as a crack addict and an acute crack user, she is primed to not only have divided attention and the inability to perceive the person's face and recall it, but she is also, there are studies that suggest that hooded strangers are wrongly identified as familiar others based upon the expectation that that would be the familiar other. So that the science sort of accounts for that piece. But beyond that, these, I've lost my train of thought, I apologize. The interlocking identifications, I apologize. The identification of others can lead the police into giving details to people which they will incorporate into their memory. So when Gomes rejects Mr. Mercado as the shooter, he continues to get information to suggest that Mercado is the perpetrator. And later on, 3 years later, when he has no actual memory of the perpetrator's face, according to Dr. Franklin, he identifies him from the witness stand, which is something that we know and understand based upon the studies and the science is something that would be incredibly powerfully persuasive to jurors. And that's the other piece of this, is that it would have been, this new information would be a real factor in the jury's deliberations because they do not understand how to use and how to account for this information. So much of this is counterintuitive, and we know that jurors place incredibly great weight on identification information. So, in the face of exonerating DNA or other information, jurors will still credit eyewitness identification experts. And when somebody like Michael Gomes, who is steered through conscious or subconscious information that he has incorporated into his memory, when he gets up on the witness stand and he says, "That man killed my brother," the jurors will believe it, despite that he will have, at that time, no ability to recall the perpetrator's face when he makes the identification.
But the real factor analysis is within the context of the discretion of the trial judge. And so the trial judge looked at all of this. The trial judge in the decision talked about the things that took away from the expert testimony that he credited.
So he was not the trial judge, Your Honor.
I'm saying that the motion judge. The motion judge took all of this into account. And so when the motion judge militates in favor of this would not have been a real factor, that's subject to the abuse of discretion standard. So tell me why that's an abuse of discretion, other than advocate gloss.
So I disagree that it's an abuse of discretion standard here because we are dealing with a trial record that this court has equal ability to assess the impact on the trial record. So this court will defer to the findings of fact where he credits Dr. Franklin's testimony, but I would suggest that a review of those findings of fact as it compares to the trial record, this court is in equal position to assess. And so I would suggest that this court need not defer to his judgment of the trial record. And I'm also suggesting that the court got it wrong when comparing this case to the other cases where this court has found that this was a real factor in the jury's deliberations. Because of the Jenga Tower analysis, I think that the court is requiring that Mr. Mercado prove that a jury on retrial would find him actually innocent or not guilty, and that's truly not the standard. In Marrero, this court said—
Where in the court's decision is that what the court said that they're doing?
Well, the court said that this information does not implode the Commonwealth's case like a Jenga tower.
Yeah, I mean, it's a bit hyperbole perhaps. He's saying it wasn't blockbuster information, but...
Sure,
Can I ask you just a mechanical question? In front of you had the transcripts from the first trial, correct?
Yes.
From the trial. That's not part of this record, or is it?
If it's not, that is my error.
Could you make them part of the record, please?
I absolutely can.
Thank you.
My apologies.
Thank you.
It seems to me that the jury's verdict reflects a necessary rejection of the defendant's testimony that he left before the shooting and accepts the timeline testified to by the two women occupants of the apartment. Can you tell me why that idea is wrong?
it's wrong because they didn't have the benefit of this new evidence. I would suggest that undercuts
How would
severely.
that affect the timeline?
Well, so if you look at the timeline, Jeanette Martinez's timeline, it says that the defendant left at about 9:20, which is consistent with his testimony. That is also consistent with his innocence. The homicide doesn't happen until after midnight. So her testimony in terms of the timeline is in fact consistent. But the jury, like I've indicated, didn't have any ability to understand why these women were unreliable, why Michael Gomes was unreliable. And so in evaluating their testimony, all that counsel is left with is this defense of that these people are sort of, collaborating to protect some drug dealer and pin it on him. When in reality, there's explanations for why they would genuinely believe that they had identified Mr. Mercado correctly as the shooter, but they did not have an adequate opportunity to see him, view him, recall him. Both Cripps and Martinez's memories and mind, and recall the testimony sort of said to them, to the jury, when I'm using crack cocaine, my memory is great, my perception is great, I have no problems. But the truth and the reality of that situation is that they have severe deficits in their frontal lobe and their ability to process and recall information. They have deficits in memory that are sort of lifetime issues. And really, these witnesses, according to Dr. Franklin, are highly unreliable. And this is an opinion that she called overdetermined. So there's multiple ways that she gets to this determination that these people are highly unreliable, unlikely to have made an adequate memory of this person's face. And that's because of the initial opportunity to view, but also if you look at, for instance, Jeanette Martinez's testimony, she waffles back and forth and all over the place on every statement that she gives. For instance, the statement of intent to kill, she says to kill, to rob, to kill, he said nothing. Every time she tells a story, it's different. But there's an explanation in terms of why she would have gotten there and why she might, by the time she gets to the jury, genuinely believe that to be true, which is persuasive to them, but they don't understand why these people would be making the mistake. And so the explanation in terms of how somebody can, mistake a hooded perpetrator for their friend, that would have been a real factor for them in terms of deciding whether or not this eyewitness identification evidence was sufficient to rest the conviction on. I understand that I'm over time. I would just ask that where we now have new scientific evidence to suggest that the conviction is based upon unreliable evidence, that this court not look the other way and affirm the conviction. Thank you.
Okay, thank you. Attorney Hanson.
Good afternoon, Your Honors. Arne Hansen for the Commonwealth. This was never a case that was predicated on a misidentification. The defendant was identified at trial by 3 individuals, the victim's brother, David Gomes, and 2 people that he was familiar with, Corinne Cripps, who had been a friend of his for 3 or 4 years, as well as Jeanette Martinez, who had spent the day with him. Now, certainly, it would be difficult for me to argue that the identification by David Gomes wasn't perfect. He identified someone else prior to the trial as the perpetrator of this case and only identified the defendant as the perpetrator 3 years after the fact in court. Certainly that identification would not survive a Creighton motion today, but Creighton didn't exist at the time of the defendant's trial. There's no point in arguing that that is a weak and suggestive identification. What we are left with is an identification by 2 individuals who are familiar with the defendant in this case. As I stated, Cripps was his friend, and they'd been hanging out in that apartment the entire night, and Jeanette Martinez was certainly familiar with him. She had spent the last few hours with him. And what we have here is more than just an identification out of the blue. Both witnesses provided context as to what transpired prior to the homicide. Jeanette Martinez testified that she saw the defendant, Joey DeStefano, and another individual who was only known as Pallone, who was never truly identified or arrested, in her kitchen talking about their plan to rob and murder the victim in this case. She provided the jury context with respect to motive, opportunity, and planning. Corinne Cripps did the exact same thing. She testified that the defendant asked her to go to the neighboring apartment, the victim's apartment, and see what they had. She went there and confirmed that they were selling cocaine, they were packaging it for distribution, at which point the defendant made his decision to call DeStefano down and to try to plan that robbery, which turned into a homicide. So we have more than just an identification out of the blue. We have planning, motive, opportunity. And on top of that, we have consciousness of guilt. Immediately after the defendant committed this homicide, he fled to Puerto Rico and wasn't identified until more than a year later through fingerprint analysis when he was arrested for a different crime. When investigators from Massachusetts went down there to interview him, he denied being Thomas Mercado, gave an alias, denied any knowledge or involvement in the crime. But Commonwealth had his fingerprints. They knew who he was, in fact, Thomas Mercado. He was brought to Massachusetts to stand trial. The defendant's theory of defense in this case was not mistaken identity. It was that, in part, it was mistaken identity by David Gomes, who had a limited opportunity to view and identify the defendant, which, again, I'm not going to touch because it's not the strongest identification. But he argued that because Pallone, defendant's cousin, was operating a drug business out of Martinez's apartment, that provided motive for those two individuals, Martinez and Cripps, to lie about the identity of the perpetrator. They wanted to protect Pallone because he was their source of narcotics. And that was the theory of defense, and that was what was supported by the evidence at trial. To argue now that two women who were familiar with the defendant could not identify him because from feet away makes absolutely no sense. The defendant's, or Dr. Franklin's testimony is inadmissible for several reasons in this case, which the Judge Gordon recognized. The first of which is that the studies that Dr. Franklin relies on deal with stranger identification. And that certainly applies to the Gomes identification, but it does not survive the Cripps and Martinez analysis. They were both familiar with him. And the court, the Superior Court, cited the Denson case, which is a 2022 case out of this court, which is very similar in that respect to the case at bar. In that case, Denson was involved in a club altercation which resulted in a homicide. He was identified on video by people that knew him, and he was principally identified through the clothing that he was wearing. Individuals were familiar with him, knew what he was wearing, and said, yes, that's the same person that I saw earlier that evening. And the expert that was going to testify in that trial was prevented from testifying because the underlying research that they were going to testify to dealt with facial recognition. So we have a very similar parallel in this case, where here we have analysis based on stranger identifications that says strangers aren't really good at identifying strangers. It does not touch on what we have before the court. The people who are familiar with each other can identify people who are familiar with each other. To suggest otherwise makes absolutely no sense. So for that reason alone, this testimony would have been inadmissible at trial, where it doesn't really, the research doesn't speak to the facts of the case. Now, Dr. Franklin's opinion is also inadmissible because it really touches on the ultimate issue that the jury needs to decide upon. The jury is the only, or the trier factor, the only people that can touch on the credibility and reliability of individuals.
We've allowed expert witnesses to testify and encouraged expert witnesses to testify multiple times in identification cases, correct?
Yes. Which brings me to another point.
They said the identification was unreliable. That's not the ultimate issue. The ultimate issue is whether or not the person did it. But this argument, I'm following you so far, but this argument, I think you're going to, it's a little far afield.
So I'll move on. The other issue is that Dr.
One thing before you move on, not on that issue, but the second witness, is that really, I understand her name, Cripps, I can't remember. She's clearly someone who knows him from prior. The other witness just knows him from that day, right? Does that make her a stranger ID, or she's sort of a mixture, right? She's not really what we would call a stranger ID, but she's also not like Cripps, a friend, right?
Yes, that's fair. So my understanding from the record is that they had met that afternoon and they spent several hours together inside the apartment. Her testimony at trial was somewhat all over the place. Mm-hmm. But I think what can be gleaned from it is that she saw the defendant and Pallone in her kitchen discussing murdering the victim, and then immediately after that, she sees him leave her apartment She says that she then saw him waiting in the hallway through the peephole with his hands in his pockets. And she said at one point that she didn't see the shooting, that she did see the shooting. She changed her story with regards to that. All of that was before the jury, so they were just in as good a position to evaluate her credibility as we are today. But what was consistent was they're talking at the table, they decide to execute their plan. He walks into the hallway. He's seen with his hands in his pocket in the hallway. Moments later, gunshots erupt and the victim is dead. With respect to the common sense principles here, this court has already addressed a lot of the issues that the defendant raises here. And it goes back to the Francis case, where the court's already accepted that we don't need special instruction, or that the jury instructions are sufficient to address specific issues and expert testimony isn't necessary. It's common sense that memory fades over time, that stress impacts memory, that people unconsciously resolve inconsistencies with facts that are acquired after the fact, that there could be coercive elements in a photo array. These are all issues that this court has ruled don't require expert testimony to be explained. And these are some of the issues that the defendant is bringing up today. Now, I think the biggest point here is that we don't really have new evidence here. We have an analysis by an expert who was hired to evaluate the situation. It's important to note that Dr. Franklin never spoke with anyone that was involved. She never spoke to Cripps or Martinez. She doesn't know what the crime scene looks like.
Well, in Gaines, we said that this type of evidence constitutes newly discovered evidence, right?
That's fair. So I'll rephrase. What we are left with here is merely impeachment evidence. It doesn't change the landscape of the evidence at trial. And that is an important distinction between other cases that have been overturned in recent years, specifically Cowles, Drayton, and Cameron. So in Cowles, that case was precipitated on the identification by one witness. That witness had substantial credibility issues, but there was corroborating evidence. There was a bloody towel that witness said the defendant used to wipe up after the fact. They did DNA analysis, and it turns out the victim's blood or the defendant's blood wasn't on that towel. Therefore, that was the one piece that buttressed the testimony of that witness. That went away. Therefore, the conviction was overturned. In Drayton, we have something very similar. We have one individual, Jackson, who testified as to what happened in the homicide and identified the defendant as the perpetrator. It turns out after the fact that another witness was with Jackson in the bathroom, stated, "I was in the bathroom with him the entire time. I did not see what happened. He couldn't have seen what happened because we were in the bathroom." That removed that linchpin and resulted in a new trial. In Cameron, it was a sexual assault case where there was DNA evidence. There was two sets of DNA found in the victim's underwear. The first significant contribution, the defendant in that case was eliminated as a source of, but there was a second piece of DNA that he couldn't be eliminated from. It turns out more advanced DNA analysis years down the road determined that was female DNA, so it couldn't be the defendant's DNA. The conviction was predicated on the victim's testimony, which was corroborated by the fact that the defendant couldn't be removed as a source from the DNA found in her underwear. By removing that DNA, it left it on the victim's identification, and the conviction was overturned. We don't have that here. We have three individuals who, at best, were impeached here. It's important to note that Dr. Franklin relied extensively on information provided by defense counsel here, and that being affidavits from, an affidavit that was attributed to Jeanette Martinez, written in 2016, statements attributed to Corinne Cripps recanting her version of events, which were put in the affidavit of an investigator, as well as an affidavit from Joey DiStefano, who testified at the grand jury, but then recanted years later. He never ended up testifying before the court and was held in contempt, did a year in jail as a result. Now, it's important to note that Jeanette Martinez's affidavit from 2016, during the evidentiary hearing, she did not adopt that affidavit. She explicitly rejected it because she noticed that her date of birth was wrong on the affidavit, and she didn't read or write English, so that she had no way of knowing what was contained in that affidavit. She did adopt a letter that she wrote shortly after the fact that discussed the defendant and Pallone in the kitchen discussing the plan, and then the defendant standing in the hallway with his hands in his pockets immediately before the shooting erupts. Corinne Cripps did not recant any of her trial testimony at the evidentiary hearing. In fact, defense counsel didn't even ask her any questions about it. So her testimony is largely unchanged. The statements attributed to her saying that she believed the wrong person was convicted for this crime was not borne out by the evidentiary record at the evidentiary hearing. And then Joseph DeStefano, at the grand jury, he testified that he was called down to that apartment to help plan this proposed robbery that turned into a homicide. He said he didn't want any part of it. He said that he saw the defendant with a gun in his waistband. They were going to go forward the plan, but he left. DeStefano then recanted all of his sworn testimony at the evidentiary hearing. But the most interesting thing about it is that he said that police forced him to say that the defendant had a revolver in his waistband prior to the homicide. And that is an important distinction because this crime was committed with a semi-automatic firearm, which left semi-automatic 9mm casings all over the crime scene, which wouldn't have happened with a revolver where the cartridges would have remained in the firearm after discharged. It's important to note that the lead detective, Detective Almeida, is a firearms instructor. He is very familiar with guns, testified at the evidentiary hearing as to how firearms work, knew what the difference between a semi-automatic firearm was and a revolver. It would have made absolutely no sense for him to tell DeStefano that he saw a revolver in the defendant's waistband when he knew that couldn't have been the murder weapon. So the evidentiary basis that Dr. Franklin based her opinion on did not exist after the evidentiary hearing. And despite that, she said that even without all of these recantations, and despite the change in circumstances, she said she would come to the same conclusion.
I guess we're drawing late, but the only question I have for you on that part is, given all of the deficiencies which are pointed out to the motion judge still found that the expert was credible. That's a bottom line, right?
Yes, that's fair.
And that's as we have to defer to the motion judge, at least in that score.
Yes. Does the court have any other questions?
I don't think so.
Thank you.